Hello everyone. Today I'd like to revisit an enduring but evolving principle in Australian family law, the Rees-Andrew principle. It's a deceptively simple idea that a parent's genuine fear of the other parent, if it impairs their capacity to care for the child, can justify restricting or even denying a child's time with the other parent. But as recent appellate authority and legislative reform show, this principle sits at a delicate intersection between subjective experience, objective risk, and the paramountcy of the child's best interests. At first instance, Rees-Andrew involved contested parenting proceedings regarding the amount of time the child spent with the father. The mother sought supervised and limited contact only. Importantly, there was no finding that the father posed an unacceptable risk of harm to the child. Instead, the mother argued that her genuine fear for the child's safety was so intense that it would undermine her emotional capacity to parent if the child were required to spend time alone with the father. The trial judge accepted this. He found her fear sincere and so overwhelming that ordering contact could damage her psychological stability and, in turn, the child's welfare. Thus, supervised contact was ordered. The key principle that emerged, and that has guided decisions for nearly 3 decades, is this: where one parent's genuine fear of the other would impair their capacity to parent, that impairment itself may justify limiting or denying time, even without a finding of actual risk of harm. Rees-Andrew recognised that emotional safety and psychological functioning form part of a child's protective environment. Fast forward 25 years, Keane tested how far the Rees-Andrew principle could reach. In this matter, the mother sought, at first instance, to prevent unsupervised time between the child and the father, citing a history of family violence and her continuing fear for the child's safety. The trial judge permitted a gradual transition to unsupervised time. On appeal, the mother relied heavily on Rees-Andrew, arguing that her fear, even if not objectively justified, would impair her capacity to parent. The full court accepted her fear was genuine, but made a crucial clarification. A genuine fear, standing alone, does not automatically engage the Rees-Andrew principle. There must be evidence of a discernible impairment in the caregiving parent's capacity to care for the child. The court cautioned against treating subjective anxiety as determinative without proof of functional impact. So Keane modernised the principle, reaffirming empathy for genuine emotion, but reinstating an evidentiary threshold. Together, these cases create a careful balancing act. Courts must weigh the benefit of a meaningful relationship against the need to protect the child from harm, including harm that flows indirectly from a distressed, anxious, or fearful primary carer. This balance has always been framed by Section 60cc of the Family Law Act, the best interest provision, which has now undergone significant reform. The changes that came about with the Family Law Amendment Act 2023 simplified and refocused the best interest test. Gone is the 2-tiered list of primary and additional considerations. In its place, 6 core factors, including, most relevantly, a new express prioritisation of protection from physical and psychological harm. Section 60cc 2A now directs the court to give greater weight to protecting a child from harm, including harm from abuse, neglect, or family violence. At the same time, the reforms broaden what harm encompasses, explicitly recognising exposure to family violence and psychological safety as central concerns. This statutory shift elevates the importance of emotional and psychological well-being within the best interest calculus. So how might this affect interpretation going forward? First, greater statutory support for emotional safety. The new Section 60cc explicitly recognises psychological harm as a primary consideration. This gives firmer legislative footing to the Rees-Andrew reasoning. Secondly, higher evidentiary expectations. As in Keane and Keane, courts will still require clear, probative evidence, psychological reports, clinical observations, expert assessments, not mere assertions of distress. Third, a more holistic assessment of harm. Courts may now consider not only physical danger, but also emotional, relational, and developmental safety. And finally, alignment with trauma-informed practice. The justice system is evolving towards being psychologically safe, not just procedurally fair. For practitioners, several takeaways emerge. Frame your client's case within the new statutory language. Link the caregiving impairment to protection from psychological harm. Support fear-based arguments with evidence. Expert or treating professional reports are essential to demonstrate measurable parenting impairment. Avoid overreach. Courts remain wary of fear being weaponised to limit the child's time with the non-resident parent. Authenticity and corroboration are key. Use trauma-informed communication. Present fear as a natural response to trauma and show how therapeutic support or structured contact could mitigate it. To conclude, the Re Andrew and Keane line of authority has always been about balance, balancing compassion for emotional reality with the evidentiary rigour required to protect the child's relationships. The Family Law Amendment Act 2023 doesn't displace that principle, it deepens it. It reminds us that protection from harm includes emotional and psychological safety. So while Re Andrew gave us the principle and Keane refined its limits, the 2023 reforms provide the legislative scaffolding for a more trauma-informed, child-centred model. Our advocacy must evolve too, balancing empathy with evidence and ensuring that when fear truly impairs parenting capacity, the law is equipped and willing to respond.